don't know, and then there's what we don't know that we don't know. And in a few moments we'll be discussing that Rumsfeldian moment and the Rumsfeldian dilemma. But right now, let me introduce myself. My name's Matt Williams. I'm your program director. And yeah, my job is going to be mostly to be writing herd on these guys who I'm going to be introducing in a few moments. But first, let me welcome you to the National Institute for Trial Advocacy's Northwest Deposition program. Thank you for being here. We have an exciting 2.5-day program for you in which we're going to work you very, very hard. I was asked earlier before we got started, are we supposed to be working at night? Which my response was, no, we get it, put into it. And so you're going to have to make your own decisions in terms of how you want to spend your evenings next week. But first, let me welcome you to NITA land, where, among other things, all motions get heard. Now, I say that, and you'll notice the snickering coming from over here, because those of you that know me know that I'm a district court judge here in King County. And I will tell you, in King County District Court Judge moment, we answer our phones, and our motions get heard. Judge Bowman being a Superior Court judge, more on that in a few moments. Where all cases get tried. Well, okay, mostly that would be in Superior Court, but there you go. And of course, where all depositions are taken for legitimate reasons, as opposed to annoy, harass, and offend. We'll be talking more about that in a few moments as well. Where all smartphones are on silent mode. Now you'll notice in years past, or I should tell you in years past, that we would ask people to turn them off. We are not so naive to suggest that we would be able to sever that aorta link that you may have with your office, your family, your Facebook page. But we do ask that you turn them to silent mode. And if you really, 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 really have to take a phone call, the fact that I should say what I'm about to say should tell you something. If you really have to take a phone call, please step out of the room to do it. And finally, where everything that happens at NITA stays at NITA. We call this the NITA privilege. I know that some of you are thinking, you know, I've been practicing for a long time. And these people are going to be seeing me maybe not at my best. Either trying to do things in a way that is different than how I've previously done them, or maybe doing things that I've never done before. And, you know, I'm a little nervous about that. Okay, I want to assure you, the NITA privilege applies. We assure you that this is not going to show up on anybody's employment evaluation. It's not going to, we don't write reports back to the partners in your firm. We don't call up your opposing counsel. But rather, this is a time for us to come together and share the collective wisdom, not only of your faculty, but of you as well. So, let's talk about what are some of the attributes of what we're going to be doing over the next couple of days. Well, first off, of course, we want you to trust us, and we want to trust you as well. We're going to be sharing with you not only experiential tips and tricks and techniques, but also a doctrinal basis as to why certain stuff works and why certain stuff not only doesn't work, but actually can be detrimental. And so we're going to be sharing those things with you. We're going to be collaborating with you, and we want you to be collaborating with each other. This is not one of those things where there's competitive grading. We do not grade on a curve. We told you about the test? Kidding. No test. Our faculty, and you'll be meeting those with your faculty in a minute, are an amazing group of practitioners that cover the gamut of civil, criminal, corporate litigation. And I think that really what you're going to get from working with them is just the nuts and bolts of look. Here are things that you can use and use instantly, and here's some things that you can be working on that will make you an even better lawyer. Our job here today is not to say, oh, you're bad, or, oh, you're so good. Our job is to take ideas and giving you ways to make yourself even better. Now, to do that, we need you to be ready to take some risks. We need you to step up beyond your comfort zone. We need you to do some things that, well, maybe you're just not quite ready to do. You're not feeling completely prepared, and it's okay. But we need you to trust us enough to be able to take those risks. So, let's talk kind of nuts and bolts program, and then we're going to get into the substance of what we're talking about for the next hour and a half. By the way, I'm going to throw a lot of information, a lot of document stuff at you in a few minutes. So take a breath while we're talking about the logistics of the program. First off, we're going to be having breaks as they're listed in your schedule. We'll have refreshments out there in the morning, in the afternoon. And let me tell you that in years past, NITA Central has said, there's restaurants. Let them eat Subway. And we found that we just lost your attention during that time frame. And so we persuaded NITA Central, they're buying your lunch. Which, if you haven't already got it, there should be still be some cookies out there. But tomorrow and on Thursday, lunch will be provided here. We've got some brown bag sessions for you to attend during that time frame. In a few minutes, each of you will be getting the breakout groups. They're being printed right now. That lists the group that you're in. If you haven't already received it by email from NITA Central, we're going to have copies of those. You're going to want to write down which group you're in and your location, because that will become your home room for the rest of the program. So I'm going to leave that up there. I'm not going to walk through it. Also, I want you to know that in terms of your CLE forms, you should have your CLE forms in your packets. If you don't, you're going to speak to Megan, who's sitting out at the front desk, and she'll get you whichever CLE form that you need, and make sure that you get it completed and turned in to Megan at the end. Parking, okay, sucks. Sorry about that. There is street parking. There's also I believe paid parking down the street over at the CLU Cherry Street Garage. Name tags. For the next couple of days, we're going to ask that you wear your name tags. That you make sure that you have them and that they're turned so that your faculty can and your cohorts can see them. That'll really help us a lot. We won't waste a lot of time going, I'm sorry, ma'am, your name, we won't be doing that. So we're just going to ask you, just wear your name tag so we can see it. It makes it just a nicer experience for everybody. If you have complaints, if you have issues, if you have problems, okay, some of your problems we can't solve, and we're really sorry about that. But you know, with drugs and therapy, no. If you have complaints, if you have problems, if a problem arises, there are 4 people that are standing by to help you. 4. I'm one of them. You can find me. You can find the Assistant Program Director, Eric Newman. You can find the Assistant Program Director, Aaron Rock. Or Megan should be available sitting right out there, and you can track her down, and she will track one of us down, and we will do our best to solve whatever the issue is that you're confronted with. We've already talked about cell phones. And in terms of the session schedule, everybody should have a copy of the pumpkin-colored schedule, right? Does anybody not have a copy of the schedule? Oh, that is so good. And last, but not of course least, let me tell you that upon your graduation from this program, we reward you with a cocktail party, in which we will provide, yes, we provide beverages of your choice, but we also will be providing food as well. Because at the end of the day, we want to reward you when you succeed. No, that's not really the reason, but we'll go with that reason for right now. So, I mentioned Megan Gallagher. Megan Gallagher is the young woman that you met when you checked in. She is the program administrator. And if you turn your attention to the back of the room, you will see Laura Williams. And you're going to be seeing Laura throughout the course of the program. She's probably going to be having a camera in her hand. Don't freak out. Laura is a high school math teacher who is also an award-winning producer of documentaries on math. And she is making a documentary about this program. And so, if you see her and she's in your room and she's videotaping you, no, we're not going to be posting it on YouTube this year. And and we won't use footage of you without first obtaining permission. But she's shooting a documentary about the program and how things work. And so she'll be shooting what's called B-roll on a lot of different aspects of the program. It is also now my great pleasure to introduce to you your faculty. First, of course, is Assistant Program Director Aaron Brock, who is the principal in the firm of
Brock Law Group. It's anonymous.
He was asked earlier, so what's your practice? And did he mention his tenure at Carney Badley? No. Did he mention his tenure at the Attorney General's office? No. Did he mention his time in the Army? No. He said, I do defense. And then he sat down. Anything that you'd like to add?
That Matt did long play album disc jockey before becoming a lawyer. I do commercial and employment litigation. Sometimes offense, sometimes defense, whoever's right.
And of course, representing the wrongfully accused is Francisco Duarte. And Francisco is now with Fury Bailey, does both criminal defense and as well also does poison personal injury.
That's correct.
Okay.
Good afternoon, everyone. I'm really happy to be here with you and hope we have a fantastic afternoon.
Our other Assistant Program Director, Eric Newman. Now, Eric hates it when I say this, but I have to tell you, Eric has a world record. Eric's world record is Eric has the world record for the world's highest billable hour. He does. And I know you want to know more.
My name is Eric Newman, and I practice insurance defense here. And Matt wants to tell that story. I had a wrongful death case a number of years ago, and as part of the site visit, I climbed Mount Kilimanjaro, and I actually billed for going to an area within the crater of Mount Kilimanjaro, about 18,500 feet, to see where the demise occurred. So there's my high school.
Hey, I may have misled you, but I did not misstate the facts.
Now, it is also my pleasure to introduce my friend, Superior Court Judge Bill Bowman, who also formerly represented the wrongfully accused. Bill?
Good afternoon, everybody. I'm Bill Bowman. My history is entirely criminal defense. I was a straight up cold marking vendor before I went to the bench, and partners with Francisco Duarte before that. It's a pleasure to be here. I look forward to working with you.
And my good friend Marjorie Tedrick, who is the municipal court judge for Buckley, as well as having an esteemed career, and you may be seeing a pattern here, not only doing certain types of aviation law, but also once again representing the wrongfully accused.
Absolutely. Good morning, or I guess it's afternoon now. Good afternoon. I'm looking forward to working with you. I think that the highlight of my career was actually in aviation. And I'll leave that to Matt.
You're going to tell the story. You might as well just tell it, Marjorie.
Some learned later today.
Yeah, basically what happened was we were opposing counsel on a case, and I was young and stupid. And I thought, oh, when she said this first time I've been in an aviation case, I went, oh yeah, oh she included my crime. And she wasn't nice about it. Now sitting next to her is Todd Henry. And Todd, you are with?
Olds, Morrison, Reaper, and Baker, Limited Liability Partnership.
And you do?
No, most of my practice is construction law and related litigation.
And immediately below him is Todd Bowers from the Attorney General's office, where he not only currently does, but used to.
Right now I'm the litigation section chief for the Consumer Protection Division. Before that I was in the complex litigation unit, and then before that I was in the criminal division.
And while we're on the subject of government lawyers, and lawyers with an extensive history, not only with the Attorney General's office, but also with other government and governmental entities, may I introduce Linda Gallagher.
Hello, I'm Linda Gallagher. I work in the King County Prosecutor's Office Civil Division, defending civil lawsuits against county employees and county agencies. I also volunteer to teach NITA whenever I can. I'm co-program director for the Trial Skills program next month, if you want to sign up for more of this fun.
Cynthia Newton has joined us from Portland. And Cynthia, tell us about your practice.
I'm Cynthia Newton. I'm thrilled to be here. I love NITA. I think it is the greatest thing for teaching law that there is. I do personal injury work from the plaintiff's side. I do a variety of different kinds of cases, including a lot of bicycle injury and unfortunately death cases, and I also love medical negligence work. It's really fun for me to be here because we are very close to the Northwest Kidney Center, which you may not have noticed on your way in, but that is my first post-college job that I got when I decided on a fateful day not to get a job training as a stockbroker. So stockbroker, dialysis, I went for dialysis, so I'm really happy to be here.
Now, Robert Vaughn has joined us from Fort Lauderdale. I have to tell you, Robert and I met for the very first time in Kosovo, where we were asked to teach a program together for the Kosovo Justice Association, or Kosovo Judicial College. And so we spent a week working with Kosovo judges, not literally training them to train other judges in the ways of trial act. But Robert, tell us about your practice.
Hi, Robert Vaughn. I'm a commercial litigator with Kim Vaughn Lerner in Fort Lauderdale, Florida. As you can tell from my accent, I grew up in rural Minnesota. Okay, all right, so we're paying attention. I'm looking forward to working with all of you and working with Judge Matt again, as I now lovingly call him, after our Kosovo experience. And I'll tell you anything you want to know, just him. So
Yeah,
looking
I'll
forward to
probably tell you about that interesting night where the power went out at the restaurant. And that was a fascinating example of asking one too many open-ended questions.
fascinating and risky. Yes.
And, of course, Kathy Franklin is here from Littler Mendelsohn. Kathy, tell us about your practice.
So Littler Mendelsohn is an employment law firm, employment defense, where we do all sorts of employment litigation, and I spend a lot of time in my practice advising clients on proactive practices, so people aren't discriminated or harassed in the workplace, and I run our training division. And I think that when I've litigated for many, many years, and one of the programs, I had 3 jury trials, I think, in my first 2 years of being a lawyer, and NITA was the program that got me through it. We actually did it in law school the whole year. Some of the professors that sometimes come in and teach here, but I commend you all for being here because it really helps, and the more you get critique, the better lawyers you're going to be.
Now, how can I describe Ruben in terms of Kathy? Let's just say that they play on opposite sides of the same field. Would that be fair and diplomatic?
Very opposite.
Okay.
Very.
Because we've also have joining us from Washington, D.C., Ruben Gutman, who is with Grant Eisenhofer. And Ruben is one of the leading whistleblower attorneys in the nation. And he's going to be doing a presentation tomorrow. And I heartily commend, it's one of the choices. I commend you to go to that. Ruben, was it last year? It was $1.6 billion.
You have to do your finger like that.
Okay. Ruben does it better. Was it Merck?
It was Abbott Labs.
Abbott Lab.
And we just finished a case against Pfizer and Subdivision Wyatt about 2 weeks ago involving a drug rapamine. It's immunosuppressant. $1 million, took a guilty plea for violations of the Drug and Cosmetics Act.
Ruben's having a good year.
But I have to say, I got into teaching. You're making me feel. Well, you always make me feel good. But I think about this, and I feel old. But it's been 9 or 10 years since I did my first session with Matt, and he was a team leader, and he's invited me to come here a number of times. And this has been a terrific experience, not only for me for learning, because every time I watch you guys, I think I learn more than I teach. So it's I hope to have a great 2.5 days.
A little bit later this afternoon, we'll be introducing you, we think, to our corporate quarters. We've had some technical issues in terms of the scheduling around that, but we'll be talking about them. And we're going to have an opportunity a little bit later in the program for us to get to know each of you a little bit better and find out more about you. Right now, we need to transition. By the way, you may have noticed something about your faculty. Pretty much every area of law
Oh, yeah.
My practice is mostly civil litigation. I do a lot of automotive products, transportation law, product design liability for car manufacturers, dealers. I also wind up trying a bunch of cases nobody else likes to try. Apple storage cases, property boundary litigation, that kind of stuff. And I got started with NITA because I was taught by one of the founders of NITA, Jim Seckinger. And out of loyalty to him and to Judge Williams, who we shared one case together.
And he'll be telling you that story because he can't help himself.
That's what I do. And I love working with the two directors, Aaron and Eric, who we all work together in the same firm.
Now you may have noticed that you've got this very diverse group of faculty who cover literally every aspect of the practice of law that involves courtroom appearances and depositions. And that's what we tried to assemble for you, to give you a very, very pragmatic, hands-on, okay, here's the theory, this is how it works. And that's what they're going to be working with you on. But we have a lot to cover in the next 1 hour and 5 minutes. We're going to talk about the basics. We're going to give you some basic skill sets that you're going to be practicing later today. And we're going to be talking not only about taking depositions, but also the defense of depositions. We've got a lot to cover. Get your notebooks out. Get your pens out, get your fingers ready on the keypad, because we're going to be moving fast. So I want to suggest to you that what we're going to be first talking about is, why do we do depositions? Why take them at all? Well, it used to be that we had long, convoluted processes in which court depositions were taken. They were filed with the court, because they're no longer done. And almost every witness had some type of sworn statement taken. The practice has evolved quite a bit due to electronic technologies, due to video technologies, but also due to the fact that lawyers have become simply more sophisticated and more cost-conscious. The reality is, we're going to be talking to you about this during the course of your breakout sessions. Every time you take a deposition, every time you defend a deposition, somebody's not only paying for your time, somebody's paying for the court reporter's time, somebody's paying for the transcript. And so part of what we're going to be working on is how to make you more efficient. Not only more efficient in the taking, but more efficient in the defending of the deposition. So, first up, why do we take depositions? Why? What do you think? Help me out here. Quinn? Why take a deposition? Who cares? Let's serve interrogatories. Why do we need to take a deposition?
I guess outside of the written discovery, you can kind of get a sense of what the witness would be like in a courtroom. And also, I think you'll hear what the witness has to say themselves instead of, I mean, particularly interrogatories are written.
Because who answers interrogatories?
Lawyers.
Yeah, lawyers. And you get it through the filter. This is the ungarnished, and you also, like you say, you get that eyes on. What kind of witness are they going to make? So that's why we might take a deposition. Greg, can you think of another reason why we might take a deposition? By the way, Barbara, in a minute I'm going to ask you why we would not want to take a deposition.
Investigate, to try to put information we couldn't have.
Right, so we want to find out the stuff that we know we don't know. Part of that Rumsfeldian moment we talked about. Barbara, why would we not want to take a deposition? Why not just depose everybody?
Well, number one, it is expensive, time consuming. Maybe with a particular case, you may not want to take a deposition because you may find out the wrong kind of evidence.
And not only you find out, because the reality is you can always investigate. Oh, isn't the internet cool? How many of you have Facebook pages? Yeah. How many of your Facebook pages are public? Yeah, that's what I thought. How many of you think that your Facebook pages are private? Oh, good. So, given the fact that we have opportunities to investigate, and one of the reasons why setting aside expense is that when we take a deposition, we're not the only people in the room, right? Because the other side is in the room. So if we want to have, if Kathy wants to expose something to Reuben, or vice versa, she's going to take a deposition. On the other hand, if Reuben simply wants to investigate and may or may not want Kathy to know about it, is he going to be taking a deposition? What do you think, Colleen? If Reuben wants to find out about something, but he doesn't want Kathy to know what he finds out. Is he going to be taking a deposition? Yeah, see, which goes to, not only are we finding stuff out, but, tying back to what Greg said, we're locking people down. And we're going to be talking and maybe even doing a little demo a little bit later during one of our choice sessions on how depositions are used to control the witness as a form of impeachment with a prior inconsistent statement, to control the story that is ultimately presented to our trier of fact. And we're going to be spending some time talking about that. So, here's the question you got to ask yourself. What's your end game? Well, first, it's to learn, because there is this Rumsfeldian moment. There is what we know, and we want to use the deposition to get sworn testimony that will never change, that this is the truth. This is what the witness knows, this is all the witness knows, and this is the truth. We know what we know. And then, as we're entering into the deposition, there's what we know we don't know about. We know that there's information out there on a particular topic. We know that the information exists, and we don't know the answer to it. And depositions can be used for that, as can interrogatories and other discovery techniques. And then finally, there is what we don't know that we don't know. And this is what comes and bites us in the butt later in the trial, later in the case. Because we walk into the deposition thinking we know the answer. We think we're just here to confirm what we know. Here's the problem. This witness has information that goes well beyond that. And in fact, we don't know that that topic even exists. And so part of what we're going to be talking about today are how to ask questions that do not presume that you know the answer. That does not presume that you are smarter or more knowledgeable than the witness, and thereby losing really, really critical information. And of course, we also take depositions to preserve testimony. Classic example, terminal patient. They're not going to make it to trial. And we'll take a video death. Or we might, depending upon the circumstances, not necessarily want a video death. We'll simply take a regular deposition to get threats to the jury. We're preserving the testimony. Or we may have a person, say a physician, that is about to travel out of the country and may get stuck someplace else. But we need to make sure that we have their testimony recorded. Another reason why we might take a deposition. And finally, to lock down information for purposes of summary judgment. And we're going to have a lecture demonstration and discussion on how to set up and how to defeat summary judgment in the course of a deposition. Okay. How do we get ready for a deposition? What do you think? Sure. How would we get ready for a deposition?
As it
This
says,
is how this works, by the way. I throw them up to you, Carson.
review all the information we have about the case, about the particular witness.
Yeah. Identify and brainstorm what is our case theory. What's important for us to know? What is this witness's role in the Great Circle? What is it likely that they have information about? Are there areas that we want to make sure that they don't have information to exclude? So then there, the negative becomes just as important as the positive. We also may want to get some intel on the witness. Now, not having necessarily given away earlier, where might we get some of the best information we can, Susanna, about our witnesses? Oh my gosh, what a cool tool it is! It is, and by the way, there's a website I want to give you right now. You should write this down. It is scary. It is called Spokio, as in like Spokane, but without the Spokio.com. Yeah, it's scary. You can have your stuff removed from there, but it will show people pictures of your house. Literally, I suspect almost everyone in this room, with the exception of at least two of us that I know of, it will show you pictures of your house. So, just a heads up, there is an immense amount of information that is available. Okay, we talked about why we're going to do what we're going to do. We talked about generally how we want to prepare for a deposition. Let me ask you, before we move on to phase one, which is the start of the deposition, Should we write our questions out before the deposition? Should we write our questions out? And sir, you're shaking your head. Why not?
Well, if you write the questions out, you won't listen to what the witness is saying. You'll just read the next question.
Oh my gosh, have you nailed it on the head? How many times have each of us been sitting in a deposition where we're listening to someone ask questions going, okay, clearly you're following the list that the senior partner wrote down for you. And rather than developing areas, you're just asking the next question. And so the witness, we're going to talk about some things in terms of things to look for, in terms of the negatives and the unstated conclusions in a few minutes. So, okay, if we're not going to write down our questions, Todd, how do we know what to ask when we get into the deposition?
Well, in my instance, I use an outline that then cites to the exhibits that I've pulled for that witness. And I talk about, with the witness, as I've said many times in classes I've taught with in format, that I think witness examination is like jazz. You got to have a theme, but you got to be able to kind of riff off it a little bit. So for me, it's a set of bullet points that I want to talk to the witness about that are generally tied to either some statement that's already been made that's on the record or some exhibit that I want to talk to the witness about.
So you go in with a general idea of what you want to talk, but not necessarily the specific question.
No, because people get locked in. If you have the next question is what color was it, you forgot to follow up with the question just before, and especially with regard to the NITA outline as we get into it, you blazed away from the top of the funnel too early.
And he just mentioned an important word that we're going to be talking about in a moment, and that is the funnel. There are two things that you're going to walk away from in terms of taking this, taking deposition in the first part of this. One of those is the funnel, and the next is this phrase. Write it down. Close the list. Close the list. Close the list. For those of you that have had me as students, you know that if I say it 3 times, it's on the test. Did I mention this? Oh, that's right, there's no test. Okay, let's go to the start of the deposition, shall we? You are in the room. The table has been set. The wine has been poured. And now we must drink it. So we walk into the room. And let's picture the deposition room. Let's picture the table. Now, at one end of the table, there is the most important person in the room. This is how this works. I throw them up. The most important person in the room. And Catherine, who is the most important? Is the most important person in the room Carlson?
It's the court report.
It's the court report. Why?
We have to build a rapport with that person, and that person needs to be able to understand everything that's said and capture it correctly.
You're absolutely right. She or he needs to do those things. But what is it about the court reporter that makes them the most important person in the room? What do you think? Holly? They're making the record. And what do we care about? Do we care about, and again, yes, we do care about in sort of a generic sense, that they like us, it's helpful, we're going to talk about why. But really, we're there to do a job. And that job is to make the record. Especially when we're taking the depth. So, we want to make sure that the court reporter has the tools that he or she needs to do the job. And so, first off, where should they sit?
Wherever they want.
Yeah. Which usually is going to be at the end of the table, near a plug, between the taking attorney and the witness. Why do they want to be between the taking attorney and the witness? Is it Brandon?
Yeah, so they can hear everybody?
Yeah, because if they can't hear it, it didn't happen. And so it's important that they can hear it. Now, does it matter which side that the attorney and the witness are on? What do you think? Does it matter?
Probably not.
With a good reporter, they will absolutely assure you that it does not. The reality is it does. And here's why. When you're working with your court reporters, ask them about machine that they use, they're not typing. It's a set of keys that translate to sounds, or rather, sounds that they translate into a set of keys. And so this is what a deposition looks like from a court reporter's perspective. Okay? Each person in the room has a designation that is a set of keystrokes. So as an example, question, answer, question, answer. Ask him a question.
What is your name? How did you get here today?
Did you notice what I had to do first? She speaks, I have to do this. Why? Question. Answer. So it's question and then whatever happens. Whatever said. Answer and then whatever happens. If you flip sides on them, yeah, a good reporter can do that. They're trained. They spent 7 years looking at court reporters. But this makes it easier. So just ask them, which side would you prefer? Among other things, you're going to score points. And they're going to be happier with you, which in turn means when they produce the transcript, we hope, that they will make us look, that they will be kind, that they will leave out the ers, ahs, ums, and all of the stupid things that we wish that we had said. If you can, give them your business card, turn your business card over, write the name of your client on the back of it, so that they know who you are, they know why you're there. If you are the person that is taking the deposition, give them a copy of the deposition notice that has the full caption and the spelling of the name of the person that's being deposed. And if you're dealing with technical terms, Ruben, what should we give them at the start of the deposition?
Give them a list of the technical terms and so they can take down spell.
Yeah, because then they'll come up with a mnemonic and they don't have to sit there and hand spell it out. They've got it there that they can refer back to it later. I once took over a case when I was at the AG's office where the prior counsel that was an assistant AG, newbie assistant AG, had taken about 10 depositions. And the court reporter was very old school. Your current court reporters will not let you do this. We're going to teach you to be attentive to this. It was very old school. That court reporter only did what she was told to do. And the new attorney never told her to swear the witness. We had 10 days worth of wonderful recorded statements that were not under oath. How useful do you think those were? Yeah, a little bit. What did I have to go do? Take them over. Why? First thing that has to happen is the witness has to be placed under oath. Whose responsibility is it to make sure that that happens, Greg? If the oath doesn't, if the court reporter makes a mistake, who's going to pay for the fact that we just have a wonderful recorded statement? Yeah. So it might be the court reporter's mistake, because they do bear some responsibility for it. But at the end of the day, we're going to require you to make sure during our first session, require you to make sure that the witness gets sworn. Okay, exhibits. Should we hand and mark original exhibits? What do you think?
Yes.
Original exhibits. Okay. After the deposition, what happens to those exhibits?
Those exhibits are going to go with the court reporter.
That's exactly right. So who now owns? Once there is that stamp put on it, who owns that exhibit?
The court reporter.
Absolutely. So now it turns out it's the original doctor's record. There is no other doctor's record. That's it. It's the original photograph. It's the original negative. Where does that original now go?
It will go to the court.
It goes with the court reporter. It gets attached to the original transcript, which then is mailed to whoever orders it. Okay? So I want to suggest to you, bear in mind, once you mark it, it doesn't belong to you anymore. It belongs to the court reporter unless there's a stipulation reached. More on that in a few minutes. Okay. These are the 4 things we're going to be talking about in terms of taking depositions. We're going to be talking about our questioning technique. We're going to talk the specific characteristics of the start of the deposition, obtaining what used to be called the admonitions, which we now call the commitments, and there's a reason why we do that. We're going to be talking about exploration and how to set up the exploration and sort of the basic construct of a deposition. And finally, we're going to briefly touch on theory testing, although we're going to have another session later in the session about that. And again, we're going to spend most of our time on extracting sound bites. We're going to do that tomorrow afternoon. So, this is the spectrum of control and information. Any questions? Oh. Kidding. Okay, first off, we have, at one end of the spectrum, massive amounts of control. A little bit of information. And that is the one fact leading question. The one fact leading question. How many facts, Holly, does a one fact leading question have?
One.
I love it when a plan comes together. Yeah, one. So how about this question? Does this have one fact? I see that you are wearing an orange blouse that has ruffles on the front and what appears to be a shoulder pad. Is that a one fact leading question? No, for two reasons. One, it's got more than one fact. Two, it's not a question. It's an observation. How about this? Are you wearing an orange blouse that has ruffles in the front and what appears to be shoulder pads? Is that a one fact leading question? No. Why?
There's multiple facts.
Yeah. So all she has to do is say, no. And I have no idea what she just said no to. I have lost control. And so I not only got no information, but I've lost control. One fact leading questions are your way of keeping control. It is the essence of cross-examination, but also theory testing. And it's down at the bottom of the funnel. More than that in a minute. So how about this? You are wearing a blouse. Yes?
Yes.
It is orange. Correct?
Yes.
It has ruffles in the front.
It does.
And what appears to be shoulder pads.
Well, that's disturbing.
See, but I still obtain information, and I know what information I obtained. That is the joy of a one fact leading question. Little bit of information, massive amounts of control. Now, sliding up the spectrum to the other side of the spectrum, we have over here open-ended questions. Open-ended questions, massive amounts of information. Little bit of control. We're surrendering control. Holly, what are you wearing?
Clothes.
Okay, what do you have like on your top?
Ruffles.
Okay, well, what do you call the piece of clothing that you're wearing on your torso?
Blouse.
And what color is it?
Like a salmon-y orange.
And would you describe that blouse for me?
Describe it how?
Tell me about list. Give me a list of its color, its attributes, and where you acquired it and how it fits.
Well, I am wearing a blouse
Okay,
that...
blah, 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 blah. You see, lots of information. Sorry, Ellen.
No.
Okay. Yeah, we've rehearsed this stuff. So now, in between those things on the spectrum, we have qualified leading questions. Oh, Holly, you're wearing a really pretty blouse, aren't you?
Sure.
Yeah, okay. How about, Holly, you wearing, by the way, I don't mean this. You're wearing a really kind of ugly blouse, aren't you?
I don't think so.
Okay. So a qualified question is like saying, well, this room is really high, isn't it? Compared to what? There's a qualifier in there. Somebody gives the witness a room to quibble. Then we come to argumentative leading questions. Argumentative leading questions are questions that would suggest that the witness, again, we're surrendering even more control here because the witness is going to want to fight us on us. And that last question, which was, it's an ugly blouse, that was an argumentative leading question. Mr. Schmidt, you hired her so that you could have sex with her, didn't you? That is an argumentative leading question. We have acquired no information. This is going to say no. And we have surrendered control to the witness. Now there's a place for argumentative leading questions across, and in And every open-ended question will begin with one of these words. It will not begin with, would you tell me about? It will not begin with, could you tell me about? It will not begin with, tell me a little bit about. It will begin with, tell me about, describe, explain, give me a list. Who, what, where, when, why, how, or when. And this is the funnel. We will have a copy of this slide. Yeah, I knew that's where you were going. We will have a copy of this slide prepared for you by tomorrow morning so that you may have this with you. This is the secret sauce. This is the goal that you came to this course. This is the funnel. And a hushed silence fell over the room. Okay, so where are we? Who, what, where, why, describe, explain, tell me about. That's at the top of the funnel. Big chunks of information come into your hopper. And you digest them, and you absorb them. And then we slowly work our way down. And we start filtering the information, and our questions become more directive. It is only in this place that our to-be verbs start to come into place. Is that right? Did you talk to her? Where we are suggesting an answer, but not asking a leading question. This is the only place, in the place of trial practice, that to-be verb questions exist. We don't use them on cross. We don't use them on direct. We don't use them at the top of the funnel. We use them to fill in. Because they're leading questions, but we're surrendering control because we're actually asking a question with us. This is the funnel. And tomorrow, or rather this afternoon and tomorrow, your mission is to stay at the top of the funnel. Your mission tonight, your homework, is tonight to have a conversation with someone. You're staying in a hotel, it could be one of your colleagues, it could be your waiter, it could be someone that you met on the street. Well, okay, be careful of that. If you are with someone, talk to that significant other. To carry on a conversation for 2 minutes, your homework tonight, 2 minutes, in which your only thing that you say are open-ended questions. Now, Robert was with me that night in Kosovo when, after a long day teaching with USAID, I was sitting next to a young woman who was an auditor from USAID, and the lights went out in the restaurant, and I was asking questions of her. And I will tell you what happened about that in a few moments, because I will tell you I was very tired, it's been a long day. If you do this for 2 minutes tonight, that person will think that you're interesting. They will think that you're interested in them. You'll learn things that you may not have really realized. By the way, I used to try this with my teenagers. Oh, the things I found out. Okay, that night was the exception to the rule, because after about 15 minutes of that, because again, I was very tired, she threw down her fork and told me that she really did not appreciate being cross-examined. She just wanted to eat her dinner in peace. Robert, who was sitting across the table... True story. True story. Robert, who was sitting across the table, said, okay, there goes our funding. Okay. So why is the question that you asked so critically important? We're going to do a fast exercise here. It's going to take us 3 minutes. You have, each of you, turn to the person next to you. Look at that person. Partner up. Real quick. You have, using only questions that begin, that can be answered yes or no. That's it. Yes or no. Find out, and I'm going to give each of you 1 minute and 1 minute. I'll tell you when to flip. Their high school mascot. Start. Yes or no, that's it.
High school mascot.
Yeah.
High school mascot. Common mascot. Other sports teams can do it. High school mascot. Animal. High school mascot.
Okay, time to flip.
Is your high school mascot too? High school in the state of Washington. High school in West Virginia.
Okay, I'm going to give you 5 seconds. You can ask any question you want. That's 2.5 seconds each. Find out your other person's in the high school mascot. Okay, time's up. How many of you now found out what the high school mascot was? And if all of you do not raise your hand, we're going to have words. Okay, why is it so critical, the type of question that you ask, so critically important? And the answer to that is very simple, because if you assume you know the answer and you ask a question that calls for yes or no, you will miss volumes of information and you will not acquire the information you seek. When you ask an open-ended question, even when I ask, what are you wearing? I got some interesting answers that I could have followed up on. We're going to talk more about that in a second. So the reason why the question that you ask becomes so critically important is because that is how, ultimately, we acquire information. We're going to circle back to this in 10 minutes, a little bit less than 10 minutes. Now we're turning to phase 1 of the deposition. We have discussed the types of questions in different places that we're going to ask in the deposition. We return to the scene. The court reporter is sitting at the end of the table. The witness is sitting at the end of the table, hands folded, looking at us, expecting. Opposing counsel is sitting next to the witness, looking at us, expectantly, and with respect. Okay, looking at us. And we are about to speak. What words should come from our mouths? Remember, everything we say is being transcribed. Visibly transcribed. In front of us. It's like being on camera, but worse, because now it's in writing. It's forever. It's worse than YouTube. What words should come from our mouth? Well, may I suggest that they know who they are. They've been placed under oath. They know who you are. So an explanation as to who you are and why you're there on the record is a waste of time and money. If you need to introduce yourself, do it off the record. The court reporter already has your name. May I suggest to you, now is the time for you to lock in, under oath, the name of the witness, so that you know who that you have there. The other identifying information concerning the witness. And then we will move to the commitments. Now bear in mind, if you don't ask them under oath their name, they could be anybody. But once you ask them identifying information under oath, and they lie to you, that is under penalty of perjury. So you have now locked into it. So your deposition could begin with a closed-ended question. It could begin something along the lines of, your name is Lauren King, correct? You are the plaintiff in this matter, is that correct? Ms. King, I have a series of questions that we'll begin with. Now, we do not call the commitments the admonitions, because it used to be we would go, and I want you to understand the rules of a deposition. Okay, do you understand what I'm about to tell you? Ms. King?
Yeah.
Okay, Ms. King, I admonish you that you are to answer the questions that I asked, and if you don't answer, or if you answer a question that I ask, I will assume that you understood the question. Do you understand that?
Yeah.
Has she agreed to do anything for me? Has she? Have I locked her in? No. And Ms. King, you've had enough sleep so that you can give your best and fullest testimony today, right? And you and your counsel have discussed the rules of being in a deposition, haven't you?
Yeah.
So you understand how this process works. Okay, see what we're doing? This is how the admonishments works. We would admonish the witness. Well now, thoughtful practitioners, such as Judge Bowman and his former partner, Mr. Duarte, understood this did not help our end game. Because the whole point here is I want to deny her wiggle room. So now, instead of admonishing her, how about if I simply acquire her agreement that certain things have been established? That they understand, that the witness understands what their rights and their obligations are. That we have eliminated the possibility that later she might claim that she was sleep deprived, that she was coerced. Oh, I didn't understand your question, and you were so mean to me with your finger and all. How about we begin by saying, Ms. Campbell, how much sleep did you get last night?
About 5 hours.
How much do you normally get?
About 7.5.
Why'd you only get 5 hours?
I was working late.
Is there anything about how you feel in terms of tiredness that would interfere with your ability to give your best testimony today?
No.
Anything that would interfere with your ability to remember the events that are in question?
No.
Anything would interfere with your ability to express what you know? Ma'am, what medication are you currently taking?
I'm not taking any.
And ma'am, how much alcohol have you had to have have you consumed in the last 24 hours?
No.
And ma'am, how much cannabis have you consumed in the last 24 hours?
No.
We're in Washington State, folks. Okay, so what have we just established? Okay, she's got no meds on board. She's had enough sleep. Sustenance. Ma'am, do you have any medical conditions that would require you to take breaks more often than an hour?
No.
My follow-up question, if the answer to that is yes, would have been?
I'm sorry, I didn't hear.
My question was, do you have any medical conditions that would require you to take a break more than an hour? No. If the answer to that question had been yes, what would my next question have been?
Will you tell me when you need to?
That's a to-be-verb question. We don't ask to-be-verb questions. Come on, help your co-counsel out. Collaborate.
How often do you need a break?
How often do you need a break? Okay. Give me another one.
What medication she's on?
What is the medical condition? Yeah, let's find out about what it is, and then we can find out how often you need a break. So it circles right back to, bottom line, what causes of confusion could there exist? Now here's a question that is frequently, or an admonition that's frequently given. Some of you may even have used this. Some of our faculty will admit that we have as well. Now ma'am, if I ask you a question, and you give me an answer, I will assume that you understood the question. Is that reasonable? Okay, A, what do you do with a witness that says no? You haven't gotten a commitment for her to do anything. How about we do this? Ma'am, if I ask you a question and you don't understand it, will you tell me that?
Yes.
And ma'am, if I ask you a question and you can't hear it, will you tell me that?
Yes.
Okay. We have just eliminated confusion and hearing out of the mix. She can't later claim, because if she does, I now have her on the record saying that she would have told me that she either didn't understand or she couldn't hear. This work? See how this works? See why they're called commitments. Okay, real quickly. Some of this stuff, explaining the process rules of the deposition, some of that you may want to do on the record, depends on the witness. Some of that, Kathy, what do you think? Would you do the state of the deposition? There's going to be a transcript prepared, that they have a right to read it and to sign it. Would you do that on the record?
Yeah.
Okay. Todd, how about you?
Yes.
Always?
Pretty much always, yeah.
Pretty much always. Why?
Because I'm always turning down.
Time-tested answer.
Yes.
Part of what
Because you beat it in my head so many years ago. Which is also true.
and of course the fact that there's a federal rule that says that the witness must be advised of that and must affirmatively either request or waive it. Yeah, it could be that too.
Forgot about that.
Yeah, that silly thing.
Can we go back to an earlier question? If I were the opposing counsel and you asked what medications are you on, and I was defending the witness, I would object to that.
Oh, very good.
I would never let my witness.
We're going to circle back to that in just a few minutes when we get to defending the deposition in question. Save that question. Ask it of me in, it's going to be in about 8 minutes. Okay? Okay, so here are some of the things that you can talk about. We're going to talk about the usual stipulations. How many of you have had an opposing council go, usual stipulations, right, council? Yeah. What did you do, Colleen?
I said, we're in a different jurisdiction, I don't know what you're talking about.
Oh, good answer. More about that in about 9 minutes. Okay, I'm going to throw these up here and let you write these down. I'm not going to walk through them because they're kind of self-explanatory. Yes, a copy of the slideshow will be made available to you. But here are some of the concepts that we can go into on the commitments. Now, you notice it says the solemnity of the oath. Because that could look like this, and be careful because you could be alienating your witness. And as my esteemed brother Bowman has frequently taught me, you always get more flies with honey than with vinegar. Man, you understand you're under oath, right? You understand that, don't you? You understand you took an oath to tell the truth. You understand that, right? You understand if you lie today, that's perjury. Got that? And perjury is a crime. It's a felony, man. It's punishable by a prison term. You understand that, do you not? And you're going to tell the truth today, right?
Yeah.
Okay. Yeah, that could be a little bit kind of hard-nosed. I'm not saying that there's not a time that you might do that, well, not in depth, but it could happen. But may I suggest that a better way to do it is, I mean, you understand that you've been placed under oath, yes? You understand that's a legal obligation, yes? And ma'am, that means, since it's a legal obligation, that if you don't tell me the truth today, that there could be penalties that are imposed, civil penalties or criminal penalties. You understand that? Okay. And so, ma'am, we're in agreement that everything you tell me today is going to be the truth, right?
Yeah.
Now, you notice there wasn't a whole lot of difference in the substantive questions, but there was a world of difference in tone. You guys notice that? Okay. Step cautiously with solemnity. So, now we're going to talk about exploration techniques, or as my brother Ruben likes to call it, crouching tiger, hidden lawyer. What can I say? We also like the last ceremony. I don't think it's a Tom Cruise makeup. So, the thing that you need to know about the exploration phase is that you need to have a basic outline. We talked about that in terms of preparation. We talked about the fact that it needs to be not prepared questions. You should have a general knowledge of the facts and the exhibits. And you notice I said a generalized knowledge. If your knowledge base is too deep and you're not able to bring yourself back up to about the 30,000-foot level, you will get lost in the bark. Not in the trees, you will get lost in the bark. I want to suggest that we can start with friendly questions, that we can begin with non-threatening topics, and that we can begin slowly to those non-threatening areas by first exhausting those things that are favorable to the witness, where the witness believes that they're scoring points on us, where they're explaining something to us, that they're persuading us. And so some of those things could include, well, how'd you get ready for today's deposition? What'd you bring with you? What'd you review? Yes, I know there's an objection, Colleen, and we're going to talk about that in a minute as well. And did any of the things that you reviewed, were you relying on them in your testimony? And of course, then we begin working on our funnel on each of those topics. But here's what I want you to think about. We open with those open-ended questions. We prod the witness. We're looking for the witness to give us a list of things. As an example, Mr. Schmidt, what is the process by which you interview potential secretarial candidates?
Which part of the process?
Take them from start to begin, from start to end.
Well, first I look at their resumes and their applications. Then if I like them, I ask them to come in when their availability, and we'll have a sit-down personal interview. And then I'll sit down with my boss and we'll make a final determination.
So, I understand. First you get the resumes and review them. If you like them, you invite them in for an interview. After you interview them, you sit down with Mr. Schmidt. Or with Mr. discuss with him.